order, and Nicola will be chairing tonight's event. So over to Nicola.
Well, first of all, welcome everybody, and thank you very much for either attending in the room or on Zoom. I'm going to begin by just saying a few words about how I came across Rachel, and because one of my other jobs is that I have been Wellbeing Director of the South Eastern Circuit for the last 3 years, and I've moved from that now into being Vice Chair of the Bar Council's Wellbeing. I followed on from Valerie Charbot and Rachel Spearing and other pioneers I'm sure you know in this area. But when I got onto the Bar Council group, which is an umbrella organisation for INS, specialist bar associations and other interested groups, a couple of names that I kept hearing coming up in relation to this topic were Rachel's and Gillian's. And it seemed to me that there was an emerging discussion about whether at work we are suffering trauma by virtue of the contact that we have with clients, by virtue of things that we see, by virtue of the things that we talk about. And I wanted to do a talk or a workshop about it for quite a while. COVID intervened, but here we are finally. We've got two wonderful speakers this evening. Rachel Francis, who's barrister at One Pump Court, practicing in immigration and family, called in 2012. And she came, and I'm going to ask her how she got to that point, to write a book with Joanna Fleck, a mental health practitioner in the area, called Vicarious Trauma in the Legal Profession. It's a great read. I would commend it to you. And it opened my eyes certainly to some of the issues in this area. I'm going to begin with a couple of quotations from it, which I hope will provide an intro really for Rachel. And then we'll move on after about 20 minutes, I think, with Rachel to Gillian Bishop, who is a partner or a consultant, in fact, in family law in partnership, a solicitor's firm dealing with family cases predominantly. And Gillian pioneered part of what we hope is the answer to this problem in our working lives, something called supervision, and she's going to tell us all about that. But to begin with the words of Baroness Helena Kennedy QC, who wrote an introduction to Joanna and Rachel's book in January 2021. I felt very privileged, Baroness Kennedy writes, to be asked to write the foreword to this special book. I think it should be used to help lawyers and their employers or professional organisations recognise that it is not surprising that they feel anxious and stressed out. And she goes on to say a few words about why this is. Acting as lawyers for people at extreme moments in their lives, facing eviction, conviction, loss of liberty, deportation, loss of their children, the end of a marriage, sexual or domestic violence, detention in mental facilities, places a great burden on our shoulders. We are conducting their cases, arguing on their behalf, and the outcome may change their lives forever. A little later in the introduction, Joanna and Rachel say this. They talk about what they call grounding practices, and I'm sure that we're going to hear a little bit more about that this evening, but those being practices which allow space and time for reflection. And they begin with these words: these practices are not about trying to feel better, but to get better at feeling. And with that introduction, Rachel, perhaps you could help us with how you came to write this book.
Thank you very much, Nicola. So the book was written by Joanna Fleck and I after a conversation that kind of sprung out of nowhere. So we'd worked together on the Committee of Young Legal Aid Lawyers some years before. I'd gone on to be the co-chair of that organisation, and Joanna had gone to explore other avenues of work, including yoga and mindfulness and more of the mental health direction. And she was very concerned that through that work, she was seeing the really sharp effects of being victims of trauma or working alongside trauma. And we were very worried by the fact that that working context, which is the context for legal aid lawyers, for social justice lawyers, every single day, day in, day out, plus the chilling effect of the Legal Aid Sentencing and Punishment of Offenders Act 2012 on funding, meant that we were at a critical point where practitioners were really burning out and having very little support, to the wire in terms of funding. And so we wanted to set up an organisation which we did, called Claiming Space, which is supposed to do what it says on the tin, a community interest company, with a few different objectives. One was to provide an immediate space for young practitioners, because that was what our experience and our knowledge base, to meet together and to support one another, peer-to-peer, so peer support, to learn, share and reflect on their practices. We developed a training that we started to deliver in legal organisations and in law centres and anybody working in the legal field of legal aid and social justice. And we wanted to present a body of information that could be taken to different representative groups to say, this is a problem that lawyers are experiencing. Please, can you now do something about it? Whether that's chambers or firms, the bar, the Bar Standards Board, the Solicitors Regulation Authority, whoever it is. And as we were doing that work, we were engaging with lots of different people, and that felt important and valuable. But we wanted to be able to kind of distill the message, present an evidence base, because that's what lawyers love. And Joanna was a practicing solicitor and I'm still a practicing barrister. And to be able to explain some of the concepts and the difficulties that we were dealing with and offer some practical solutions with some qualitative examples from the profession. So what better way to do it? The book. So we wrote the book, and then when we published it in February 2021, we were in a pandemic. So everyone was dealing with all of this in their living room or their child's bedroom or their living room with their partner and their children who had COVID or didn't. And so it kind of exploded as a particularly resonant theme. So that's a very lawyerly, long-winded way of saying there were lots of different things that fed into this book, but that's essentially how we got there.
So what's vicarious trauma?
Vicarious trauma. Now, we have defined it in the book in a neutral way. So we use it as a neutral term to describe a mode of exposure. So quite simply, being vicariously, so indirectly exposed to trauma. And if you think about it in that way, that means that every single one of us in this room and in the virtual room is experiencing vicarious trauma on a day-to-day basis. Because we're watching CCTV, because we're witnessing a client break down when we take instructions from them, because we're watching clients give evidence in court. So that's how we describe it. And then we use that mode of exposure to describe a process and a series of outcomes. So the two processes are potentially a paradigm shift. So what we mean by that is a shift in your worldview. So if you started your legal career with quite a sunny side up view of the world, it may be that through the process of being vicariously exposed to trauma over time, that shifts. And you're more suspecting of a new partner who your friend describes as being quite cross quite a lot of the time. You are more anxious about kind of day-to-day events. You maybe avoid the news and so on. So that's the kind of general worldview paradigm shift process of being vicariously traumatized. The second is the set of emotional and behavioral responses. And this is what we feel individually and within organizations. The negative that springs to mind immediately is feeling symptoms of burnout, which I can come back to, compassion fatigue, so feeling like you care too much and you're exhausted by it, or you cannot care anymore because you have simply heard too many examples of a client who has done XYZ behavior. And also secondary traumatic stress. So all of us will have read medical legal reports describing symptoms of post-traumatic stress disorder with respect to clients, and sometimes we begin to see that clinical symptomology present in our own behaviours or those around us. So that's the negative outcome of the processes from this mode of exposure. There can be a neutral happy worker who is impervious to the effects of vicarious trauma. I've never met them, but I'm sure they exist. There can also be the positive impacts or positive outcomes of vicarious trauma, which is sometimes called vicarious resilience, which is that enormous sense of bliss you almost get where you travel through a case with a client and the most extraordinary hardship has happened to them, and yet they come to court, they turn up, they give their evidence, they may even express gratitude, and you've kind of seen them through that process and you can feel really rewarded for it. So that's the kind of map of vicarious trauma, but at its very simplest, it is a mode of exposure. That is how we have sought to define it, because it doesn't then restrict it to, well, it's not me because I don't feel bad like that or I don't feel good like that. It is you because you work with that material. And so that's kind of our starting point.
And what sort of material would be relevant to this?
So I think witness statements, client interviews, videos, CCTV, it can be anything. It can sometimes be the way that a client presents. Some of the clients that stay with me the most have said the most benign things. The two examples that I can think about is one is about a forklift truck and one is about eggs. Okay, so on the face of it, not particularly distressing fact patterns, but the stories around it were just very intensely moving and upsetting. And also looking at photographs, you know, that kind of forensic analysis. And you are required to really get into it. I think that's one of the other aspects of it that makes it a particularly pernicious issue in this area of law. You don't just think, oh gosh, I don't think I'll read that page of the book. You have to analyze it. You have to go through the CCTV, the phone records, potentially watch the ABE interviews or whatever it is. And that kind of depth of exposure and the quantity of exposure and the frequency of exposure, back-to-back cases, can mean that there's this tipping effect into that negative outcome, as it were, of being vicariously traumatized. Or
ABE interviews, we should say, for anybody who doesn't know, are achieving best evidence interviews used usually in serious sexual offences, for example, in criminal cases, which will be a complainant witness giving their account to a police officer.
Yes.
So that's the sort of material that it applies to. What are the things that we should look out for?
Well, I think, so I'm coming at this from myself and my experience as a barrister, which is one form of practitioner in a very diverse field of practitioners, all of whom are affected by the exposure, being exposed to this material. And that I include in that people who are working front desk in chambers or solicitors, taking the telephone calls, particularly interpreters. And as an author of this book, what we wanted to stress in the book is that this type of work impacts everybody differently. Everybody will have trigger points. Everybody will have particular issues that are difficult, and that will change over time. So it's really about getting a sense of what is normal for you. Are you working extraordinarily long hours in a way that you wouldn't normally? Is your sleep disrupted in a way that it would not normally be? Do you find yourself particularly triggered by a type of case in a way that you haven't experienced before? And that might be to do with a life event. So having a baby can change your perspective on non-accidental injury cases, or being bereaved can change your perspective on working on a case where somebody has died in the case or is close to death. So it's really being mindful of how you function effectively and safely as a practitioner, and whether any aspects of your behavior are changing. And quite often it's not you who notices. Somebody you live with who's like, for goodness sake, will you please stop telling me that I'm cutting the carrots wrong? You're just up in my grill about this. What is the problem? They're just, you know, that's how you cut them for a stir fry, you know, and you haven't realized that you're being so aggy and you've been like that all week. And actually then you stop and think, do you know what, actually I've just done back-to-back child abuse cases and I'm not sleeping. So it's really having a method that allows you, for example, the grounding techniques that you mentioned earlier, Nicola, to check in with yourself and see what is going on, and making that space a priority so that you can notice.
What might we notice in others? Because I think you talk in the book about it being a sense of self-care, but also collective care.
Yes. So I think, again, it will depend which workplace you work in, but there may be people in your office who are never taking lunch breaks, are always working really late, are in a high state of distress, or a high kind of like fight or flight, or they're kind of the opposite of that spectrum, being very lethargic and kind of dull, and oh, you know, I've heard it all before, I can't be bothered to engage with this. Oh, God, I had this client who was exactly like that last week. And one of the ways that we try to kind of navigate those ends of the perspective is to talk about something called a window of tolerance. You know, there isn't one perfect point where we are this like brilliant worker who functions perfectly. We have a window within which we can tolerate the work that we do, because sometimes we do just have to tolerate it. It's really uncomfortable, it's really difficult, the clients are unpleasant. I'm sure that never happens to anybody else. Or the fact patterns are really unpleasant, or your opponent is really unpleasant, or the judge is really unpleasant, or all of those things. So what is that window of tolerance? Maybe somebody is crying a lot. Maybe they are really losing it. Maybe they're going out drinking a huge amount. Maybe they're describing to you a very chaotic lifestyle in a kind of frenzied way, you know, that doesn't seem normal for them. You know, there's lots of people who like to live chaotically. That's absolutely fine. You know, or people saying, one of the quotes in the book that I always go back to is about a barrister, because we interview practitioners for this book to kind of have some qualitative data, who talks about going to court to do a placement order application. So in the context of a child being permanently removed from their family to be placed for adoption, not wanting to go to court so much that they got off the train early and sat on the platform before they could get back on again, because the stress and the pressure and the trauma of what they were about to experience was so significant that they were just like, I just can't actually do this. So I guess if people are giving you that kind of information, that's a good sign, I would say, that they are finding it difficult to manage. But there's lots of examples in the book of kind of how it impacts people differently. So I wouldn't want to define it, but those are maybe some examples.
Yeah. And do you think perhaps for each of us, there are differences in how it impacts us over time?
Definitely. And I think there's a kind of real mixture. I don't want it to be suggested that if you're not tough enough, if you can't cope, if you're not resilient enough, I have a real antipathy to the word resilience, because it suggests when it's used that you can't survive, or you're not resilient enough. It seems to be the sort of second half of the sentence. Sometimes we get better at managing it because we gain a greater awareness of what our boundaries are. But often the opposite occurs, which is that we're so worn out by the work that we're doing that we're not noticing the earlier signs, and we're actually very burnt out, and we're too tired to stop. And we just say, oh, well, I know that this month is really mad, and the following month is probably okay. Then I'll book a holiday. I'm just going to get to the end of that, okay? And then it's going to be fine, isn't it? Okay, so yeah, it's going to be fine.
I mean, there are plenty of people, whether that's judges or others in senior roles in the profession, who would say, well, that's just the job of the bar. What do you say to that?
The first thing I would say is, if that was true, we wouldn't be sitting here. The fact that this talk is being brought together by organisations of such stature within the profession is indicative of a paradigm shift. This matters to the bar now, and it matters to the judiciary now, and it has always mattered, but it matters in a way that people are doing something about. So that's the first thing I would say. The second thing is that just because a particular profession function in a particular fashion, it does not mean that it's healthy, and it doesn't mean that it should continue. And it is very difficult to talk properly about this issue without acknowledging that right now, in particular areas like family, like crime, in many others, everybody is at breaking point, because there is so much work, such a backlog, that people are just like, well, I just don't feel like I have time to deal with this, so I'll deal with it in 2024 when the backlog is gone. And what's very annoying, I would say, about vicarious trauma is it's a process. If there was a magic button, I would have pressed it already for myself and any other colleagues who I've ever talked to about this in any talk I've ever spoken at, but there is not. It is a process of awareness raising, talking about these issues, taking the sting out of them, because they are mental, emotional, psychological health issues, and that has always attracted a level of, oh, I don't really know that I want to talk about that much. And the fact that we're having the conversation reduces the burden on anybody who wants to come forward to speak about it, because they feel like there's a space for them and people will listen to them and they have a language to talk about it. That was a massive issue, in fact, for the book. And your first question, Nicola, why did we write the book? We wanted to give people a framework and some definitions to offer it to them to use to talk about this issue. Because sometimes if you can give something a name, it helps you feel like your experience is valid. It helps you communicate it to somebody else. And it helps you feel like your experience is shared. And I think one of the most difficult things about the attitude of that sentiment that you put forward, Nicola, and the process of being exposed to trauma it is so isolating, because you feel the effects of the work that you're doing, and you don't know whether anybody else feels like that. And you think, well, I shouldn't stick my head above the parapet, because if I do that, maybe everyone will think that I'm a joke, or I can't do this job, or I'm not tough enough, or this is what the bar is, so get on with it. Classic British stiff upper lip. And I think that that is so dangerous, because it means that people burn out. It means that people harm themselves in the way that they behave, whether that's drinking to excess, committing infidelities that they might not wish to, physically hurting themselves. And that can have extremely serious consequences, of course. And also, we are custodians, if you like, of extremely difficult, complex cases for highly vulnerable individuals. So if we're not going to do it for ourselves, why not do it for our clients? Sometimes I think to myself of situations that I've heard of, whether that's my own experience or others, we're almost negligent when we turn up to court, you know, and that is a situation to be avoided from a financial position, if nothing else, you know. So it is important for all sorts of people in the system and for it to function well. But it is really difficult. I don't say that, you know, lightly at all. It's tough.
So what can we do individually and collectively from the experiences that you found in the barristers you spoke to? What are your recommendations, as it were?
So I would say, talk about it and learn about it. The more that is done, the more you have a language for yourself, the more you have a communal language, whether that's in chambers, solicitors' firms, at court, robing rooms, wherever it is. Use peer support, whether you set up formal groups in your office, so at a particular place and time where you know people will be there to hold a confidential space to allow you to share practice examples and reflect on them and bounce that around, or whether you do it informally, just have a space in chambers or offices where you can do that. Get supervision, which is what Gillian is going to talk to us about, and you know, carve out the space to see how your work is impacting you. And that must be an individual space as well as a collective space. So those are the primary examples that I would give. There's 4 of them. I should have done a cluster of 3. Terrible. But what I would say is that we have dedicated a section in the book, chapter 10, for team and peer action, and in chapter 9 on individual action, and in chapter 11 on organizational action. So there are more examples, but talk about it and learn about it, access peer support, get supervision. I have clinical supervision and I love it. And there was a 4th point and I've forgotten it. Okay. So there we go.
2 points that I think I've noticed in the 24 years or so that I've been at the bar, which have changed. And I'd be interested to know whether you think that these have had an impact on the level and type of trauma which we are being exposed to. It is first that when I started, you always had a solicitor as a barrister at court. They'd come, you'd never walk into a cell on your own. You had company in those situations. And the second that is increasingly the evidence that we are dealing with is visual. Whether that's a judge at the Bailey who is watching time and time again CCTV of somebody being stabbed and dying on the pavement, or whether that is sexual films that have been filmed often of an offence taking place that we're obliged to watch. So those 2 things, what impact do you think they've had?
The first one on the, if I can call it company, I think it immediately takes a practitioner 1 step away from being able to unpack the difficulties of a case, to share it, to feel like they are working in a team, and that applies to both parties to the company, and to be able to reflect on what has happened. So that takes that support away. And yes, of course, you then have the tube or train journey home or car journey home, or move from your living room to your kitchen if you're working from home, to unpack it. But sometimes people are reticent about picking up a phone and saying, I had a terrible time at court, whereas they would just be like, oh, for God's sake, Nicola, that wasn't that awful. Oh my goodness, I can't, you know. So it takes the immediacy of that downloading away. With the visual evidence, I think it has a really pernicious effect. And I know that there are cases being brought, challenges to the necessity to watch traumatic evidence. And I think those challenges need to be brought with more regularity, because possibly as a result of the profession being burnt out or used to this, or it just being what we do, often so many people are watching a piece of evidence that don't necessarily need to, when it is that visceral, that I think that's hugely problematic. What it leaves you with, I think, is, you know, these indelible images which just live rent-free up here. And because we're very screen focused, it's not necessarily that easy to dislodge them. I don't have an answer to what to do about that other than the challenges, but I think it places an even weightier burden on the profession and the judiciary to manage that material very carefully, but for us also to have adequate time to unpack that. You know, the specific challenge I'm thinking of was a case involving a particularly egregious form of child abuse, if it's possible to kind of categorize it in that way or create a hierarchy. And one of the practitioners involved in the case had very recently had a child who was the same age as the one who was being abused. And that brought into question whether it was necessary for that particular legal team to watch that video. We need to push back on that, I think, and think very carefully about how we unravel the rent-free videos that live here. It's really very difficult, I think.
What sort of reception have you had from the book with those who are in a position of power to do something about it?
Well, I would say everybody is powerful in the first instance. So, I mean, we have had an enormously positive reception, is the first thing to say. And I want to feel that everybody is empowered to do something with this book, because even if you just have one more conversation with a colleague who you think is really at rock bottom, more than you would have done because you've read something in this book, then it's a success. One single person doing that is a success. In terms of those people who are in power, we have been invited into various chambers by heads of chambers or kind of chambers leads to talk on this issue. And we have been invited to speak about it in magazines and at events, which is always very positive. I consider the organisations that have invited me here today to be very powerful, so that's a good reception from power. We need to do some door knocking, to be honest with you, about, you know, with the regulators and so on, but it is quite tricky because legal aid and social justice law is one facet of many facets of law in which you're, you know, I mean, you don't come down to this area of law until you've gone through all the training and learned all the bits of law that you never come back to until your friend asks you to read their contract on something you don't know anything about. Anyway, so we need to speak to the regulators more, but overall, very positive. I think people do want to open the doors to these issues. Whether they want to change the practices in organisations, it's probably a question that Gillian can answer better than I can. Because it is system change and people don't like change.
Yeah. Well, that's probably a good point to ask Gillian to tell us about what you've been doing to help your organisation and those in it to survive.
Well, thank you very much. First of all, thank you for inviting me. I'm delighted to be here. I'm going to be slightly left field by starting my presentation by reading a poem. Poetry is one of my ways out, if you like, one of my ways of dealing with the job. So I'm going to share this poem with you. It's called The Journey, which I appreciate is a very hackneyed phrase these days, but it's called The Journey, and it was written by the late, great American poet Mary Oliver. I don't know if any of you know it, but if you don't, and even if you do, just listen to it carefully and see if there are any parts of it that resonate with the job you do. The Journey. One day you finally knew what you had to do and began, though the voices around you kept shouting their bad advice, though the whole house began to tremble and you felt the old tug at your ankles. Mend my life, each voice cried. But you didn't stop. You knew what you had to do, though the wind pried with its stiff fingers at the very foundations, though their melancholy was terrible. It was already late enough, and a wild night, and the road full of fallen branches and stones. But little by little, as you left their voices behind, the stars began to burn through the sheets of clouds, and there was a new voice, which you slowly recognized as your own, that kept you company as you strode deeper and deeper into the world, determined to do the only thing you could do, determined to save the only life you could save. The whole house trembling reminds me of the court system. It's kind of trembling through an earthquake, I think, at the moment, particularly in the criminal field. It's pretty bad in family law, which is my field. And that old tug, oh gosh, can I take the day off? Can I go to my child sport day when I've got all these clients who are needing me? Mend my life. I mean, you know, everyone we meet is asking us to mend their lives. But actually, at the end of it all, only we can change the way things are. I agree with what Rachel said. We all have power. And what we have to do is get together and pool our power and bring about change. But ultimately, the only change we can make to our own lives, we're the only person who can do that. I'm going to talk to you about supervision, and supervision is something that's really quite hard to talk about because unless you experience it or can watch a demonstration of it, it's quite hard to sort of tell you what it is. So I think I will just tell you my story, and through telling you my story, I will, I hope, tell you a little bit about supervision and the difference that it can make, the difference that it's made to my life. I'm an individual, so my story will be different from anybody else's story who's had supervision, although I was pleased to hear Rachel say that she has a clinical supervision herself, and thank goodness you do, because it's pretty essential, I think, for the sort of work that we do. Vicarious trauma applies to people doing criminal law. It applies to people doing personal injury, certainly family, anybody who's working in a field which involves clients in trauma, because the very act of doing that means that over the years, that trauma accumulates. Just as an aside, by the way, I think older lawyers telling younger lawyers to be more resilient is probably the most unhelpful thing that they can say if they're not going to back that up with the support that the young lawyers need to be resilient. You can't just say be resilient and flip the switch and suddenly you're resilient. You need the support. So I just wanted to say that. Now, I started working in the law, believe it or not, 41.5 years ago, when I started my training contract, or article clerkship, as it was called then, in a West End firm. And I worked pretty much the whole time without any career breaks, apart from a 3-month break in 2001 when I had a sabbatical. But I pretty much worked full time from September 1980 to July 2020 without a break. And during that time, I mostly worked as a family lawyer. I say mostly because when I started, family law was part of a litigation department in most firms. So I was doing personal injury and employment law, all sorts of bits and bobs, including planning. It was a bit random, but family was part of that package. And in due course, after 13 years doing a mixed bag of work, I, with others, set up my current firm, Family Law in Partnership, in September 1995. You know, and that was fantastic. I thought I'd done pretty well doing that. And the firm, over the first 20 years of its life, it's going to be 27 this year, it flourished and our brand flourished, and we were, you know, mentioned in dispatches in all the directories and the things that somehow seem important, though aren't really. But by 2013, I was feeling pretty disillusioned. Here I was, the founder of a firm which was doing it incredibly well. I had amazing colleagues who I really cared about and who cared about me. I had some lovely clients. I worked with some great barristers, and I had some good friends in family law. But I was feeling really disillusioned. And I think that what had happened was that I'd kind of fallen out of love with the practice of family law. I was increasingly exhausted. And what was exhausting me was other lawyers, other solicitors, I ought to say at this point, other solicitors who were of the sort who would issue applications in the court rather than pick up the phone to have a conversation to see if there was a way of resolving cases. They seemed not to care really that it wasn't going to necessarily benefit their client to go to court. I mean, sometimes court will be a benefit, but in most cases, certainly in the family law field, the majority are capable of resolution without going to court. But some people out there just issued applications and worried about everything else later. I was also quite exhausted by clients who just wouldn't or couldn't make sensible decisions, who wouldn't or couldn't have realistic expectations of what might happen in their case, who wanted to punish their former partner, whether that was in monetary claims or regarding the children or whatever it was. And try as I might, they would insist on my doing things which I knew were not going to be in their interest. And clients who would want me to believe 100% their version of events. And even though I would ask questions which would maybe get them to reflect about whether they had any part to play in the place they found themselves, they wanted me to mirror their perception of what had happened to them in the correspondence that I was writing. So I spent a lot of time battling with people. Let's not issue court proceedings. Let's sit down and talk about it. Maybe there was a part you had to play in this, etc. I was making good money, and I hesitate to say that really, because I know that people in the criminal bar probably don't make that great money. I certainly wasn't making as money as the corporate lawyers, as much money as the corporate lawyers, but making money was never my motivation. Like many people who entered into family law, and I'm sure criminal law too, did so because they felt that they wanted to help people. And that's fantastic. And lots of people still want to help people, but the system, the process can often get in the way, and the sheer busyness of the job gets in the way. If you're working, you know, pretty much 24/7, then your ability to help people inevitably diminishes. If I struggle to breathe, I can't help anyone else to breathe. I've done a lot of personal therapy over the years. Various things have driven me into the arms of various therapists. And I'd learned a lot about myself. And I'd been to all sorts of courses telling me about the psychological aspects of divorce and separation, and I kind of understood about that. But what I hadn't understood was the need to marry those two bits of learning together, that my self-awareness and my awareness of what might be happening to my clients were actually connected by the relationship that I and my clients, I and my colleagues, I and the other professionals had, that actually they were all relationships. And if I understood more about relationships and my part in them, I would perhaps understand or be better able to assist. But I hadn't come to that realization. So I was feeling disillusioned. And about 10 years ago, just about that sort of time, I met a psychiatrist called Chris Mills, who lives and works in Bath. And we were both at a conference in York, and we got chatting. We went to each other's workshops. We met again the following year and the year after that. And eventually he phoned me up and said, I'd like to suggest something to you. Will you come and have lunch with me? I'll come to London and take you to lunch, he said. So I needed no second invitation. And Chris was telling me about his involvement with family lawyers in Bath. He got involved working with them when the family law world adopted a process called collaborative divorce, which was a no court approach. It was an approach where people sat down around the table together, they signed an agreement not to go to court, and they kind of basically worked it out. And the idea was that this couple, as well as having a lawyer and maybe a financial person helping, would also have somebody called a family consultant, a role that Chris could perform to help the clients get into a kind of better space for that negotiation. But what he soon discovered was that it was the lawyers who needed him more than the clients, because he realized that they had no idea what they were doing in that space. And so he started supervising them, and he wanted to spread that word a bit wider. He was astonished, as indeed am I, that psychiatrists, psychotherapists, family therapists, and others in the mental health field were obliged to have supervision in order to be able to continue to practice. But lawyers, often dealing with the self-same clients, don't. In fact, if you talk about supervision to the regulators, they presume you mean case supervision. They don't presume you mean supervision of self. So Chris very cannily offered me a free supervision session. Well, to get the chance to talk about myself for an hour for free, you know, what's not to like? He said, look, if you don't find it helpful, fine, we've had a nice lunch, we'll have had a meeting, we can see each other next year at the conference in York, and no harm done. Well, I was hooked from the first session that I had, and I was very fortunate that I worked with people who heard my enthusiasm when I said, we need to be making this one-to-one confidential supervision available for everyone in the firm. And it is available for everyone in the firm. And I think there's only one member of the team who hasn't taken it up, and I have yet to discover why. But so much so, we now have 2 supervisors working with our solicitors, from directors to senior associates, junior associates. Everybody who wants it has it, and they have it monthly or bi-monthly as their circumstances allow. I had it monthly, and as I say, those first few sessions taught me the importance of marrying my own self-discovery about who I am with my understanding of what happens to clients when their relationships break down, and understanding that I wasn't just a lawyer to that client, that I was a human being in relationship with another human being. And that's something that certainly in the family law field, that's not really understood. We kind of hide behind this carapace of lawyer, and we forget that actually at the fundamental to all that we do is that human to human relationship. So supervision was a necessity. I realized that it was a necessity. It offered me a space to unload, to be listened to be really heard for someone to say to me, I heard you say this, and I'm wondering whether, or when you said that, I really sensed a deep-seated anger in what you were saying. Were you feeling angry? What's that anger about? We do a lot of talking, lawyers, don't we? But we don't get listened to very much. And by being deeply listened to, I was suddenly freed. I was freed from fear, and I was freed to do things differently, to make changes to my life. If we had the time, I would tell you about my theory about fear, which underlies everything lawyers do. There's so much fear, starting with getting it wrong, starting with, imposter syndrome and all that sort of stuff. Fear of actually just not, of having too much work, and the contrary to that, fear of not having enough work. We're never satisfied. But after 6 months of having supervision, Chris started talking to me about burnout. And he said that he thought I was suffering from burnout, or that I was on the verge of suffering from burnout. And that really stopped me in my tracks, because it never occurred to me that that feeling of disillusion that I was having, which I kind of blamed, I knew exactly who to blame. I knew who to blame for that. It astonished me that it could actually be something to do with me, that it would be, that I had taken on too much, that I was possibly burnt out or about to be. And over the next few weeks and months, I came to the conclusion that he was probably right, that if I didn't take stock and really look at what needed to happen, that I would kind of slowly grind to a halt at best, and at worst, who knows. I was having heart palpitations at the time, so my body was telling me, my body was kind of screaming at me, something's wrong here, do something about it. By the way, we often forget to take notice of what our body is telling us, but our body tells us before our brains do. So what happened next? I'd started supervision in about 2013. In 2015, I had another short break. I took 7 weeks off work, February, March, and half of February and all of March. So that allowed me to kind of get my body back into some sort of sense of recovery, and enabled me to clear my head a bit. And one of the things I decided to do when I came back was, and this is easier for solicitors, I acknowledge, I decided to only work 9 days out of 10, the old 9-day fortnight as it became known. So I had 2 days a month, not weekends, but 2 days a month, where I could do what the hell I liked. Go for long walks, go to an art gallery, lie in bed all day, didn't really matter. It was 2 days for me. And then in 2017, almost exactly 5 years ago today, I set up with a couple of my colleagues a training organization called Flip Faculty, which was designed to teach family lawyers the skills that they're generally not very good at, like listening and asking questions in a kind of deep and meaningful way, and boundaries, really bad at boundaries. And then I needed to move further. I was coming up towards 60. I wanted to stop doing the day job when I was still able to do something a bit different, but nevertheless related to the work that I'd been doing for the best part of 40 years. So I stood down as a director of my firm, became a consultant with the idea of giving up client work and doing more training and more about well-being. It took me, as you might imagine, another 15 months to actually hang up the day job boots. But I started also training to be a supervisor for family lawyers. I say for family lawyers because that's my tribe, but actually the skills I have as a supervisor are available to anyone who wants to talk about their work. So summer 2020, I gave up the client work. I took up supervision as a role. And I'm rather pleased to say I became a law care champion, and we've got the law care CEO here tonight, Elizabeth Rimmer. At her persuasion, I became a law care champion. So I get to talk about this a lot, which I'm delighted about. And I still see my supervisor, except he no longer supervises me in my client work. He supervises me in my supervision work, but I've got the same supervisor. So I asked myself, what would have happened if I hadn't had supervision? I mean, I'm not suggesting that if you have supervision, you all stop doing the day job and you all go off and do something else. But I had done 30 odd years at the coalface before I started having supervision. And I was, as I say, I was approaching 60. So those sort of what am I going to do next were very much in my mind. Supervision helped me see that I gave too much of myself to my cases. I kind of cared too much. I would lose sleep worrying about clients who wouldn't take my advice because I knew they were heading for an absolute crash. I didn't mind for myself, I minded for them, and I kind of really cared. Supervision taught me that my most difficult client was my most difficult client because ultimately they reminded me of myself. And that was like scales falling from my eyes. I suddenly understood why that person had been an absolute thorn in my flesh for so long. So supervision gave me the physical, emotional, mental, spiritual ability to do the job well and to survive it well. It was my oxygen mask when I was doing the client work, and it kind of remains my oxygen mask because my clients are the lawyers now, but they're still clients. And I have no idea how I got through 32 years without having had supervision. I got through it. Whether I got through it well, who knows? I like to think that I would have got through it a lot better, that maybe I would have lasted in it longer. Maybe I wouldn't have been quite so kind of desperate to stop by the time that I did. So it kind of goes without saying that supervision is something that I recommend for all lawyers, barristers, solicitors, anybody dealing with clients who are in trauma, because as Rachel has described so eloquently and fluently, we do get affected, and if we pretend that we don't, we're fools to no one but ourselves. It certainly helps us survive having supervision. It probably helps us thrive, particularly in a system which is doing its best to bring us all to our knees, I think. So ultimately, my message is this: our destiny's in our own hands. Nothing will change unless we individually and collectively make it change. And if you are determined to save the only life you can save, your own, then you've got a good start. All you need to decide is what you're going to do about it and how